Hello, all of you. I know this video is coming after a long delay. I apologize for that. In any case, without wasting time, let me get into the contents of this video. As all of you would know by now, last Tuesday, the Supreme Court, in an interim order, stayed the broadcast of all the episodes of this program, Bindas Bol, which is aired by Sudarshan News Channel, because the Supreme Court had observed that the contents of the show tried to malign the Muslim community by accusing it of slyly trying to infiltrate the civil services. Here, let us I'm not going to get into the substantive issues, whether this is hate speech or not. Rather, I would like to throw out a question on the process involved in this case. Some of you might have already thought about it, I assume. Anyway, now, when there are officers and authorities designated within a relevant law to deal with complaints about the contents of a broadcast show like the one which Sudarshan News has just released, should the courts intervene and impose a pre-broadcast restriction on a show? Is the fundamental question. This is typically called as prior restraint in free speech cases, right? That is before the show or the article gets published or broadcasted, you put a restriction on its transmission or you put a restriction on its publication. This is called as prior restraint in free speech cases. Typically, this discussion comes when the state, when the government imposes such prior restraint. But when the judiciary does it, when the courts does it, when the courts impose such a restriction, then there is a different concern. That is the concern about when we already have officers and authorities designated under a particular law to deal with such similar complaints, then why should the courts intervene before that? Because the court should intervene only when there is a dispute of a nature, or dispute with a legal issue in it, right? Now, the idea behind this is that, only when something is published or broadcasted, right, can we actually determine its contents fully and determine its impact and thereafter assess whether there is a crime or any illegality is being committed, right? In light of that, I think we should all ask that question: shouldn't the courts be more hesitant to pass such restraint orders, especially when the statutory authorities have not been approached for and when the broadcast has not fully taken place? Mind you, this show that we are talking about by Sudarshan News, it's a multi-episode program. It's not like a single episode program. Therefore, this case came into the Supreme Court, I think, when about a few episodes had been released, not all the episodes. So that's something that we need to keep in mind. And another basis of this particular point that I'm raising is that there is this conceptualized theory that an institution like the media should be self-regulated from within and without much external control like that from the courts, because freedom of press is critical to the functioning of a democracy, and unnecessary plugs cannot be put on it. This is the larger theory behind. Now, in this case, the relevant law would be the Cable Television Networks Regulation Act. It came in the 1990s. There are grievance redressal mechanisms under this legislation. To be precise, section 19 and 20 of the legislation that I just talked about, it allows the central government or any officer that it authorizes to regulate the transmission of any such broadcast show if that show violates the program code. Now, the program code is given under Rule 6 of the Cable Television Networks Rules 1994. Rule 6 has a particular ground which states that no program on a TV channel should be carried which contains attack on religions or communities or visuals or words contemptuous of religious groups or which promote communal attitudes. Now, the basis on which this news program of Russian news is being challenged is on the grounds that it is a hate speech, or it has contents which are of the quality of hate speech against a particular community. And what we see here is that Rule 6 of the Cable Television Network Rules 1994 has a provision to deal with such content, has a provision to raise complaints against such content on TV channel. Moreover, there is this News Broadcasters Association, which is a association that represents private news channels. They have their own set of codes and their own set of code of ethics and code of standards that news channels which are members in their association should follow. Even though it's not really a binding authority, it does contain certain grievance redressal mechanisms under it. So therefore, it's not that we didn't have other recourses to take in this scenario instead of filing a petition directly in the courts. Now, while talking about this issue, I am reminded of this 2017 judgment in Common Cause versus Union of India. This is a case in which a division bench of the Supreme Court, led by the then Chief Justice of India, Justice Jagdish Singh Kehar, and Justice Dhananjay Chandrachud, they made it clear that normally the court should not engage in pre-broadcast censorship of shows, and all grievances against such content should be made before appropriate authorities under the law, and that too only after its publication. They were clear about that. So therefore, that's something for us to keep in mind, that what made the Supreme Court change its or alter its stance in this particular situation. Justice Chandrachud is part of both the benches, the bench which stayed the Sudarshan News program, as well as the bench, as well as part of the bench which decided the case that I just talked about. And moreover, it's not merely about the presence of self-regulatory or statutory mechanisms that are available. It's also where we have to look at is that criminal law also allows for post-publication remedies, where you can file an FIR against the concerned TV news reporter or the channel for hate speech under Section 153A Indian Penal Code. The law allows for such a remedy in criminal law, right? And most of the remedies under the law are post publication for a legitimate reason, as I mentioned above, which is about the importance of freedom of press and the need to ensure that unnecessary plugs are not put on it. I'll end this video with a final point about how at times judicial censorship, without any set standards, is dangerous because it leads to an influx of subjectivity. Different judges will have different perceptions. That is the reason why many of these issues are dealt within statutes, because statutes will lay down certain pointers, certain standards that need to be looked at by the concerned authorities while deciding these issues. But when it goes to the courts, such prior restraints before publications are dangerous without any set standard. I would suggest that law students should definitely think about this question and develop a thought process on this issue, right? So the idea behind this video was to sort of give you a sense about the importance of this perspective with respect to this issue concerning Sudarshan News, not beyond the substantive issues about is it hate speech or not hate speech, but also the procedural side to it, right? So thank you so much.